Derek Chauvin trial, day 12 today, was opening arguments, happened earlier this morning. Nothing super explosive, kind of what we expected from both the prosecutor and from the defense team. We're going to break that down. We're going to show you exactly what happened in the trial today, sort of the Cliff Notes version. Obviously, it was taking place all morning, and we've got a lot to get to. So let me show you the trial board just so that we can see where we're at and sort of get our bearings straight. Today, we heard from a lot of different prosecutors. So you can see on this side, we have the prosecutors who are representing the government. On the other side, we have the defense, Eric Nelson, Derek Chauvin, and his assistant. Then we have the judge right up here at the top, Judge Peter Cahill. The prosecution today was really comprised of Mr. Blackwell. Jerry Blackwell came out and gave the opening arguments. Then we had Matthew Frank do some witness questioning, as well as Steve Schleicher. So we had three different people today who were presenting the government's case in chief. And just sort of a recap, last week and the week preceding, we were really focused on this section of the board. We wanted to fill this panel up. Who are the jurors going to be? And this is representative of the jury panel. You can see we've got a lot of women on the panel. I think it's 8 white folks and 6 people of color have all been identified and placed on the panel. And this lone juror number 15, was removed from the panel, so we'll get rid of him tomorrow. But he was there this morning. He's no longer there because they're going to be focused on the other 14 jurors. This is a full panel. So we started today, oral arguments from Mr. Blackwell. Matthew Frank was another prosecutor asking questions of witnesses, as well as Steve Schleicher. So a lot of people. As I mentioned, this was the jury panel. Number 15 got booted out of there. These are what the demographics look like. And you can see here, this is sort of what we're dealing with. A lot of people, pretty varied panel, if I can be candid about it. I mean, we got a lot of different people, kind of a female heavy panel, but the demographics are even more diverse than Minneapolis itself, because we looked at some of the census data from Minnesota, and you can see here that it's even more diverse than the general population in that part of the country. So a lot of stuff happening today. The jury was seated. I want to show you what the juror process being seated looks like. Not anything actually eventful or even that interesting, but I just wanted to show you this because it's sort of symbolic. We went through 2 weeks of jury selection. The judge seated them, swore them in. Then we can finally get off to the content.
All right, good morning, everyone. Members of the jury, before we begin the trial, we'll administer an oath to you so that you may take on the important duty of being judges. In this case, you will be the judges of the facts, and I will be the judge of the law. I'd ask everyone in the courtroom to stand while the oath is being administered. Raise your right hand, please. Do you swear or affirm that you will be attentive during this trial and follow the instructions of the court, so that you may reach a fair and just verdict, that you will not discuss this case with anyone until submitted to you for deliberation, and will keep your verdict secret until it is delivered to the court? If so, say I do. Thank you. You may be seated.
That's that. Jury panel sworn in. So there we are. And the trial was off to a start. We have Jerry Blackwell, who comes up next and is going to give us the opening arguments. Now, I wanted to just point out what the judge said. I am the judge of the law. You are the judge of the facts. The jury, the panel there, they're going to be the people who are deciding what the facts are, what happened. You're going to hear different presentations, different interpretations of the facts, but that's what they're there for. And so when people are asking questions about, well, what if a prosecutor said this or a defense attorney said that, and they're sort of bickering over the facts or arguing over the facts, sometimes they're bickers, sometimes they're legitimate arguments. And the decider here is the jury panel. They're the ones who get to tell you what happened. And so this is why jury selection was so important, and why these things can be so contentious, because you can have very, very what feel like facts on either side. If you're a defense attorney or a prosecutor, it's like obvious. Look at it, it's obvious, but not really, because there's alternative explanations for it. And ultimately, the jury is going to be the one that decides and tells us what the facts are according to what they see in court. So we're going to go in, and the way that I'm framing this today, we've got 2 presentations. We've got about 2 minutes from the prosecution and about 2 minutes, a little bit longer there, for the defense. And they're going to both present their opening arguments. And so I wanted to just sort of give us a high-level framing of how this typically works. I'm already seeing criticism on Twitter and from other people out there sort of in the news and the commentariat who are saying that, gosh, this prosecution was just so eloquent. This was so captivating. I listened to this argument and man, it was passionate. There's a lot there. Then we switch over to the defense, and the defense is like boring. He's talking about Bates numbers and about reasonableness and about reasonable doubt and these sort of concepts that are like opening up a phone book and reading that for leisure. It's not interesting. It's not even compelling. It's kind of nuts and bolts. And so people are watching this and they're doing this compare and contrast thing, and they're saying, oh my gosh, the prosecution was just brilliant. That was an Oscar award winning performance. Then they go to the defense and like, that was pretty boring. It was pretty bland. And I don't disagree. I agree with that sort of analysis. But that doesn't mean that it's bad. That doesn't mean that it's a wrong thing. This is kind of how it goes. This is how the cards just fall when you are a prosecutor or a defense attorney. Prosecutors typically are very emotional. They have a lot of that type of language in their toolbox. They get to come out every time and say, this was a travesty of justice. This was horrendous. This was insanity. I can't believe this happened. This was a harm. This was a threat to society. And they get to sort of stand on their soapbox and scream that from on high, while the defense has to sort of play a different ball game. We're playing the game where it's typically, it's a reasonable doubt. There's alternative explanations for these things. And those tend to be a lot more boring. They're not nearly as provocative. They're not nearly as interesting. And you can just sort of see how this fleshes out with basic criminal cases. So let's take a DUI, for example, right? If you're a prosecutor and you are trying to convict somebody who is alleged to have committed a DUI offense, what do you get to say when you go into court? This guy was driving drunk, hammered drunk. This guy was out on the roads. Your kids are out on the roads. There's other people. He could have killed somebody. This was somebody who was doing something so reckless that they got behind the wheel. They made a terrible decision, and they were out on the roads jeopardizing and endangering all of society. And unless we do something, ladies and gentlemen, then this is going to be something that continues to fester in our society, and you've got an obligation as a juror to come out there and enact justice and make sure that this man does not get away with that, right? A lot of emotion, a lot of color in that type of a statement. But what if you're a defense attorney? What do you say? Well, no, actually our client wasn't drunk. There was a misinterpretation of the toxicology reports. There was a crime lab error. Something happened where there was a disconnect when they were being processed down at the crime lab. There was a chain of custody problem. And so the toxicology report, that's actually not even our client. That blood vial belonged to somebody else. It's just a disconnect case, right? Not anything that interesting. It's just a simple crime lab problem. Well, they just mixed the numbers up, mislabeled something, an officer is missing, something is falsified. It's just not there. Sorry, right? Sorry, government. You didn't prove your burden. So one is very interesting, very provocative. The other's not. Same thing with the domestic violence case, right? This guy's an abuser. This guy beat his spouse. This guy could have beaten your wife or your daughter or your son. This is egregious conduct. That's the prosecutor. The defense comes through and says, no, she was drunk. She just slipped and hit her head. She's got an alcohol problem, right? She was drunk. Our client didn't do anything, standing there. She's an alcoholic. She gets irate when she's drunk. She fell, hit her head. That's what caused the damage. Nothing to do with our client. But one is very compelling. You can get angry. You can get forthright. You can just come out there with a mission. The defense is typically like, hey, reasonable doubt. Right? This is a reasonable thing. Here are some alternative explanations. And so it's a lot less colorful. It's not nearly as interesting. It's just part of the rules. That's just how it goes. So I just wanted to frame that out for you so you're going to see this because it follows that exact pattern, that exact template. We're going to hear from Jerry Blackwell, who comes out. He's a prosecutor. He's the government's prosecutor. He comes out and he does oral arguments, opening arguments. So we're going to hear from him. Then we're going to hear from Eric Nelson. And the prosecutor here, Mr. Blackwell, I think he spoke for about an hour, laid out a lot. Very good. Very nice opening statement. I'm going to show you about 2 minutes of this. Then I want to run through some of his additional slides. Then we'll change gears a little bit and talk about Mr. Nelson. All right. So here is Jerry Blackwell in court today, this morning, for opening arguments for the Chauvin trial.
May it please the court, counsel?
Sped up at 1.5
jury,
speed.
good morning. My name is Jerry Blackwell, and I apologize for talking to you through this plexiglass, but it's probably the least of the gifts that the pandemic has given us. You're going to learn in this case a lot about what it means to be a public servant and to have the honor of wearing this badge. It's a small badge that carries with it a large responsibility and a large accountability to the public. What does it stand for? It represents the very motto of the Minneapolis Police Department: to protect with courage, to serve with compassion. But it also represents the essence of the Minneapolis Police Department approach to the use of force against its citizens when appropriate. A sanctity of life and the protection of the public shall be the cornerstones of the Minneapolis Police Department's use of force.
Now, let me pause on that real quick. So it says sanctity of life and the protection of public shall be the cornerstones of MPD's use of force policy. And so if I had to speculate, I think that what they're trying to do is sort of take the sting out of out of the defense. I'm thinking government because it's the police officer, but it's the defense. They're trying to kind of take the sting out of what the defense will introduce later down the line, which will ultimately be about what happened to my video here? Which will ultimately be about, no, he was following force, right? He was within the Minneapolis Police Department's use of force guidelines. This wasn't excessive force. This was just something he was allowed to do. He was doing it. He was executing it according to the policies and procedures that are in place for their department. But what the government wants to do, what the prosecutors are trying to do now, is to say, yeah, but those underlying policies can't supersede your greatest policy, which is to provide for the sanctity of life. You might have all of these other things, but they can't be in contradiction to the bigger overarching theme of why we exist as a police department in general, which is to preserve life, enforce justice, or whatever is in their mission. So they're sort of going higher up the hierarchy, saying, well, yeah, that use of force thing that you're going to rely on, that you're allowed to do, technically, yeah, but it doesn't give you the permission to override the sanctity of life, the protection, some of the fundamental reasons that we're here in the first place. And so what happens in opening arguments, you're not really supposed to be too argumentative about anything. You're supposed to just tell the jury what they're going to see and sort of what the facts are as they unfold. And so what he's trying to do is he knows bad facts are coming down the pike, and he's just trying to remove some of the sting from them right away, set the theme in the jurors' minds to say, yeah, I mean, it may have been an official policy that was allowed, but it was never part of the policy to kill people when you are a police officer, right? And so that's kind of where that line of conversation was going. So let's start that over.
Court, counsel.
I won't
Ladies and gentlemen of
interrupt.
the jury, good morning. My name is Jerry Blackwell, and I apologize for talking you through this plexiglass, but it's probably the least of the gifts that the pandemic has given us. You're going to learn in this case a lot about what it means to be a public servant and to have the honor of wearing this badge. It's a small badge that carries with it a large responsibility and a large accountability to the public. What does it stand for? It represents the very motto of the Minneapolis Police Department: to protect with courage, to serve with compassion, but it also...
All right. Well, I don't know why that's erroring out, but I don't know what's going on because it just errored twice now. So here is where he goes with this. This is the timeline of what they're sort of piecing together. So he walks us through this entirety, this entire timeline, sort of piece by piece. Takes him an hour to do it, and he really references in this 9:29. How long did this whole process take? 9 minutes and 29 seconds. And a lot of this is I think, very well done. Says here at 8:19 we got George Floyd handcuffed. Then at 8:22 he says, my stomach hurts, my neck hurts, everything hurts. So he starts, his initial sort of complaints come right at about 1 minute after the fact. Then at 8:23:59 final words, I can't breathe. Officer Lane at one point at about 8:24 says, I think he's passing out, right? And so what they're going to be doing now is trying to use this second sort of 3 minutes and 51 seconds to say this is where a lot of the sort of correction should have come in. And they're showing you these frames. So when they're superimposing these two things happening together, George Floyd and his statements, his language, also juxtaposed with the imagery that we saw. So we've got Chauvin's knee on the back of Floyd's neck taking place for about 3 minutes and 51 seconds. And from the time that George Floyd goes silent with the sporadic movement, which they're going to identify as a medical condition when somebody is basically suffocating to death, they're going to say that these spasms had nothing to do with drugs. They had everything to do with the fact that he could not breathe and his body was sort of, gasping, sucking involuntarily. When you go, you take that big deep breath, your body's trying to do that. And it's, even though you're not conscious, sort of the reptilian part of your brain is now triggering the mechanisms in your body to inhale oxygen. And so he's going through those involuntary spasms. They're going to bring in medical experts that say, yeah, that is indicative of suffocation or asphyxiation. And that is what ultimately caused him to die. And so, two things are happening. Number one, they are trying to take this and sort of draw out the causation here to say that the causation started right at about halfway. So as soon as he started, this I can't breathe, and now he's doing these involuntary spasms, this is where we can get real clear on what was causing the remainder of the silence and the non-responsiveness. What was the cause of it? Was it the drugs, or was it asphyxiation? And so they're identifying this moment right here, this at 8 minutes and about 23 minutes in, 8:23:59, they're saying he had these involuntary sporadic movements that was caused by the knee on the neck, which was evident. This happens as a result of asphyxiation, and this was the new cause. So it's two things are happening. They're saying that was the cause of death, but also the failure to do anything after that point contributed significantly to the cause of death. So they're sort of achieving all of the necessary causation elements in all three of those charges by focusing on that one transitionary spot. So well done from the prosecution. I think very compelling. Officer Chauvin lifts his knee off of Mr. Floyd's neck. Now the defense, of course, is going to go through here and say all this is caused by the drugs, had nothing to do with the knee on the neck. All of this would happen anyways. And that Floyd saying I can't breathe 27 times was part of his modus operandi. Had nothing to do with the fact that he literally couldn't breathe. It's something that happened in prior arrests, and he was saying that even before he made it to the ground, right? So, they're going to take that, they're going to draw that out a little bit, but it is compelling from a prosecution standpoint. I think it stands on its own. Also can take a look here. It says on October 16th, 02, revised August 17th, 07, based on the Fourth Amendment's reasonableness standard, sworn Minneapolis Police Department employees shall only use the amount of force that is objectively reasonable in light of the facts and circumstances known to that employee at the time force is used. The force shall be consistent with current training. So that was another slide. They are also telling us we're going to be hearing from a lot of different doctors who are going to prove that the cause of the death was asphyxia. So this is from the government's opening statement. They gave us a whole slew of witnesses that they're going to be calling. We got a forensic pathologist, pulmonologist, cardiologist, two people who work in critical care, somebody who works in emergency medicine, internal medicine, and then toxicology, which will be a very interesting one because the defense is presumably going to have their own toxicologist. And so this is just to prove that the cause of the death was asphyxia. And I said that this in my Defending Derek Chauvin video, this was the main crux of this entire case, right? Causation. What caused the death? And here you can see 1, 2, 3, 5, 6, 7, 8 different witnesses, expert witnesses, who are going to all come in and testify to that. It's that important because this entire case is based around causation. Pretty obvious on that. Now, here are some other expert witnesses who are going to prove that the use of force was not reasonable. So we're going to have Jody Steger, who is a chief of staff, the inspector general for LAPD, 20 years with the LAPD, sergeant and officer. We have another person, Seth Stoughton, who is University of South Carolina, tenured associate professor, specializes in criminal law, procedure, police law, and policy. So we'll see what Seth has to bring in on this. And then that was the government's case. I mean, it was very compelling. I thought it was well done. Not lost on me that they selected the only African-American that, as far as I can tell, who is on the prosecution team to come out, introduce themselves to the jury, make sure that we have that component of this case front and center. There's good reason for that. I think it was a smart move, pretty obvious, but a good obvious move. You should take those easy moves. And so if this case is about, sort of the racial killing by white people of black people, you put the only African-American person who is on that side front and center. Let him do the opening arguments. Very powerful. People might think that is inappropriate or it's a little too racially provocative or whatever. I don't think so, right? This is you assemble the team and you play the plays that work best for your side. Government is doing that. Doing a good job of it. So then we're going to change gears. We're going to see that Eric Nelson comes out. Very brief opening statement, 20 minutes. Doesn't even get into all of those other issues. Talks a lot about logic, emotion versus logic, and it's not even that interesting. It's kind of not supposed to be, though. It's supposed to be about reasonable doubt, about a lot of the more boring arguments. defense just doesn't have the opportunity to make those claims. So let's take a look at what Eric Nelson had to say earlier this morning.
May it please the court, counsel, Mr. Chauvin, members of the jury. A reasonable doubt is a doubt that is based upon reason and common sense. At the end of this case, we're going to spend a lot of time talking about doubt. But for purposes of my remarks this morning, I want to talk about reason and common sense and how that applies to the evidence that you're about to see during the course of this trial. Reason is an idea that wholly permeates our law, our legal system, and it forms the foundation. And you will see and hear that repeatedly throughout the course of this trial. What would a reasonable police officer do? What is a reasonable use of force? What would a reasonable person do in his or her most important affairs? What is a reasonable doubt? As such, reason dictates and necessitates how the evidence must be looked at and analyzed in every single case. And common sense is exactly that. It's common sense. Common sense tells you that there are always two sides to a story. Common sense tells us that we need to examine the totality of the circumstances to determine the meaning of evidence and how it can be applied to the questions of reasonableness of actions and reactions. In other words, common sense is the application of sound judgment based upon a reasoned analysis. And that's what this case is ultimately about. It's about the evidence in this case. The evidence that you will see in this case during this trial. It is, I agree with counsel for the state, it is nothing more than that. There is no political or social cause in this courtroom. But the evidence is far greater than 9 minutes and 29 seconds. In this case, you will learn that the evidence has been collected broadly and expansively. Minnesota Bureau of Criminal Apprehension employed nearly 50 case agents, analysts, and technicians to investigate this case. The Federal Bureau of Investigation included at least 28 additional agents in their investigation. These agents combined have engaged in an extensive and far-reaching investigation. They have interviewed over 50 members of the Minneapolis Police Department, including the officers who responded to the scene after Mr. Floyd was brought to the hospital. They interviewed members of the Minneapolis Police Department command staff. They interviewed officers who oversee training and policy-making decisions within the Minneapolis Police Department. They have interviewed nearly 200 civilian witnesses in this case. Some of these witnesses saw the entire incident, some who saw a portion of the incident, many who saw nothing, and some who had some piece of information to give to the officers, and others who had nothing. These agents interviewed the numerous medical personnel who attended to Mr. Floyd, and they interviewed the numerous firefighters and paramedics who responded. Agents executed approximately a dozen search warrants in this case to gather information, and in the end, you will hear a term throughout, I believe, this case called the Bates stamp number. The Bates stamp system is a way for lawyers to keep track of the case, to make sure that we are working from the same set of documents, the same set of evidence, to preserve the integrity of the investigation. You will learn that we are approaching 50,000 Bates stamped items. So this case is clearly more than about 9 minutes and 29 seconds. As you all saw during jury selection, the witness list in this case neared 400 people. So how do we begin to analyze and organize this evidence? I suggest that you let common sense and reason guide you.
All right. So definitely a different approach here. So we kind of saw some of it from Mr. Blackwell. I did post a full clip over, I think, on Twitter today. If you missed the clip that I was going to play, it's available there. I don't know why my slides weren't working, but basically he comes out and he talks about, he's really focusing on the 9 minutes and 40, I think they expanded the minutes. It's over 9 minutes now. He's focusing on the 9 minutes. That is where the microscope is. They have a magnifying glass on this really narrow, small little window. They want you to focus right there on the 9 minutes and 46 seconds or the 8 minutes, 46 seconds, right there. It's all there. And they're going to just be surrounding this case with cell phone video and witnesses and people who were there and interpreting that event. Because that's all you need to know. We all saw the video. Isn't that enough? And so what the defense attorney is trying to do is come back out here and say that is not even scratching the surface, not even remotely. In fact, there's 50,000 Bates stamps, Bates stamp documents. That is a ton of stuff. That is a ton. We saw that the government had, I think, 8 witnesses that they're bringing. The defense has their own witnesses. And so what Mr. Nelson's doing, while the government wants you to look right there, he's saying, no, this whole thing is way bigger. Way bigger. So use your common sense. Just use your reason. If it really is as simple as Derek Chauvin just put his knee on his neck and killed him, well, then what the hell are all these other witnesses for? What is all this material? What is this entire production for? Because it's not that cut and dry. There's actually a lot of other explanations as to the cause of death. as to how Chauvin was trained to respond to these things. And so it is not particularly interesting. If you watch Mr. Nelson's opening argument, 20 minutes, goes out there, hey, use your logic, use your reason. You just saw the government come out here, went on for an hour, blah, 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 right? All these timelines, all of this stuff, putting together PowerPoint slides, whatever. It's all nice, it's all pretty, but it's way bigger than 8 minutes and 46 seconds or 9 minutes and 46 seconds. It's way bigger than that. And so all he's trying to do is just hit the reset button. All right, you heard that for an hour. Reset. As you're listening to this evidence over the next 2 to 3 weeks, give it a fair shake. Use your common sense and apply it towards the law at the end of the case. So I thought it was good. I thought it was effective. Very boring. Nobody cares about Bates stamps and that type of stuff. Very, very, very boring. Kind of monotonous stuff. Reasonable doubt. Okay. But that's what the defense does. That's just how it works if you're a defense lawyer. It's not as interesting. Every now and then, you see what you see in the Hollywood movies where, oh yeah, but it was that person with a knife on the 3rd floor at 9 p.m. after the maid went to sleep, right? Like that's in the movies. That's in Hollywood. This is, no, the government has the burden of proof. They got to prove their case. Eric Nelson doesn't have to prove anything. They got to prove it, and they got to prove it beyond a reasonable doubt. So he's resetting the volume. I think it was pretty effective. Let's go through a couple witnesses who were called. Nobody really groundbreaking. This is a witness called Jenna Scurry, and so she was in court today. She's a 911 operator, and she was testifying today what the government is doing. So the government presents their case first, and then the defense gets to cross-examine their witnesses. So the government calls witness number 1. Name is Jenna Scurry. She's a 911 operator. She took the 911 call, and she's somebody who also is able to sort of view things on the monitor at a certain period of time. So the government called her. Really, the testimony that I think they wanted to get out from her was that this was not an ordinary 911 call. She gives them that. And they're using this to admit some of the phone calls and then get into further conversations down the line about other witnesses. So she's sort of the opening of the case, right? You got to have an opening scene in your trial or in your movie or in your TV show. So this is her 911 call. All starts with the 911 call. All right, here she is. So she comes in, testifies today. I want to show you, her testimony was not that particularly interesting, but I wanted to show you something that's going to be happening a lot in this trial as this case moves forward. So this is when the government is asking her questions, and they're trying to get in certain records that we're not going to spend much time on about the 911 calls. So they're asking her questions. What this prosecutor is doing is laying what's called foundation, okay, before an exhibit gets submitted into court. So he's saying, do you recognize this? Do you use this on a daily basis? Is this kept as part of your job? Is this familiar to you? Is this something that you would use when you're performing this task? Is this something your supervisors would also recognize? Okay, because you use this every day. How long have you been using it? 5 years. All right. It's foundation. They're establishing that this is something familiar to that person, and then they're going to admit the exhibit into the record so that everybody can see it on the other side, so that the jurors can see it, the judge can see it. It's part of the official record. And so what's going to happen here is this is very basic, very routine, but I just wanted to pause on this because this is the first time that this is going to happen. I want you to note what number exhibit this is. So we have hundreds of exhibits, and I want you to note what happens after he moves to admit the exhibit. So he has this woman say, yep, I recognize it, all good, and I move to admit it. He goes back to Eric Nelson, the defense lawyer, who then has to look at it. Right? They got to look at these exhibits. Well, I don't have a copy of that. What is this? What does this mean? And you're going to see that this takes about a minute, maybe 90 seconds. This is going to happen a lot, over and over and over again as this trial continues to move forward. So just get used to this. This is laying foundation and admitting exhibits. This happened earlier today.
I'm showing you what we've marked as Exhibit 151. Do you see it on your screen?
No. Oh.
Now do you see it?
Yes, I'm using the judge's computer.
Okay. Do you first of all, do you recognize what this document is?
Yes.
And how would you refer to it so I get it right?
It is the printout version of the call that it came in from 911.
So as calls are processed through the center, a record of that is made that looks like this.
Yes.
And is this kept in the ordinary course of the business of the call center and keeping track of what it does?
Yes.
And have you on prior occasions relied on something like this to recall what happened during the call?
Yes.
And is it something that you're able to see even sometimes during your shift?
Yes.
And would this come up on one of the multiple screens that you have if you wanted to?
Yes. Everything looks different. It would take a lot of explaining, but yes, we see all of this information.
Your Honor, then I would offer Exhibit 151.
All right, so he moves to admit it. Now he's looking through his files. Well, I don't have that. What is that? I don't have a copy of that in my disclosure. So they get up, they're talking about it. He's saying, he puts his mask on. And they're all, it's funny because this is just something that happens. And it's, all right, let me check. Okay, let me see if it's there. All right, let me look it over. All right, this is what this is. Okay, let me check my files again. He's looking at his computer. No, we don't have that. What is that there? All right, I guess we do have it. All right, so they come back in, exhibit received, right? And it's just sort of this thing that happens behind the scenes that may not seem like that big of a deal, but it's very important, right? This is a document that's going to go in front of the jury, and they're going to be able to reference that. So Eric Nelson's taking a look at this. All right, what are you throwing in there? What are you trying to slide in there? And so you're going to see a lot more of this as the trial unfolds. So just a little bit of a inside baseball going on there. Going to show you another one of those here in a minute. This woman, her name is Alicia Euler. She's 23, was from Arizona, and she is somebody who was not particularly helpful. She was I think a witness on the side of the road, and you're going to hear the prosecutor, Mr. Schleicher, coming in, asking her questions, and I think what he's trying to do is lay some foundation. So she is somebody who recorded a cell phone video from the side and is not really remembering much of anything. Not a particularly useful witness, but what we're trying to do now is sort of frame out the incident, frame out the side of the road, all of the traffic, all of the people, the witnesses, the bystanders, everybody there. The government is trying to flesh out who was there, what they saw, where did this material come from. So they can't just, pull off a Facebook video, says somebody was live streaming the George Floyd murder. No, we're just going to take that video and just shove it into court. Remember what happened during the impeachment proceedings? They were just referencing news articles that turned out to be significantly wrong later as part of their official government documents, as part of the official trial record, right? Can't do that in a real court. You got to have evidence. You got to lay foundation. You got to bring in the people who shot the video to have them validate the material before you get it submitted. That's what this woman was doing. And so Alicia Euler, you can see she's got an Arizona t-shirt on there. Represent there, Alicia. Here she is responding to the government's questioning.
Do you recognize that person, that officer? Do you recall seeing an officer interacting with a group of bystanders who would later gather?
I think so.
Can you physically describe that person as best you can remember?
I don't really know. It's been so long.
Do you recall previously talking about a bald police officer?
I think in one of my videos I was talking to a person.
Okay. A bald officer. Do you recall as you sit here today what the bald officer did?
I think he was like yelling at people, like before or after this.
Do you also recall describing a tall officer?
Yeah.
What did the tall officer do?
I think he was like, I don't remember. There's so much.
Let's resume play.
Come on, Alicia.
There's always some shit going on.
Pause for a moment. Now, what we heard there that was imposed at the same time as the surveillance video was your second recording. Is that right? Mm-hmm. Yes?
Yes.
And again, that was your voice when you said there are always some...
Yeah.
Right. Okay. Had you continued to watch these events out the window that entire time?
Did I watch it out, like outside?
From inside?
I think I went outside to smoke a cigarette.
So, not a groundbreaking witness. That's okay. Just, very preliminary stuff, just reporting on her version of what she saw. Doesn't remember much of it. Kind of, comes into court. Not particularly useful. Doesn't answer a lot of questions, but is able to detail what's happening with that cell phone video. Then we transition, and we have this gentleman who was a security guard. Remember him? We talked about him previously, and I didn't capture his name. It's not in my notes for some reason, but he was the guy that there were some motions in limine that were being filed about before the trial started. And specifically because he has a lot of experience. I think former law enforcement, and he's a wrestler. Shout out to the wrestlers out there who has some training in this, right? Has experience with dealing with people physically. And so they're bringing him in there. He was also a bystander. And so we're going to see two clips from him. I think the first one that we've got here is where he's identifying the defendant. So remember what we were talking about with laying the foundation with the 911 witness. the woman who was testifying about what she heard on the phone call and so on and so forth. Well, you also got to identify the defendant. You also got to make sure that the person who's sitting in court is the person who's supposed to be there. And you go through this formal ID process. This is what it looks like. They use this witness to help facilitate that. So let's see here. Well, all right. I don't know why that's not working either. So my videos are not working, but this is the witness now.
What are you seeing?
Detailing where he's at.
I hear an older guy saying it's going to be okay, quiz this and arrest. They're going to get you up and put you in the car. And just hearing people, different people actually vocalizing their concerns to the officer. And hearing George on the ground pretty much pleading for his life, saying he's sorry, I can't breathe, I want my mom, just please let me up, and things like that.
So, while we still have Exhibit 19 up, can you show the jury after you got done observing, where did you go from there?
I ended up somewhere in this vicinity throughout the whole time.
Okay. And so when you went over by the curb area there, what did you see happening on the ground behind the squad car?
Well, before I walked up, I noticed that it was an officer standing right here, kind of pretty much dictating the crowd from only standing on this curb right here where they're at. Noticed that part right away. And then I finally noticed it's going to be on the opposite side, but I noticed George's head was kind of sticking out from the side of the car. And then I noticed Officer Chavez right here with his knee circulated on George's neck. But this is all happening on this side of the car.
All right, we'll get to that in just a second while we're still on this floor.
All right. So again, this witness is coming in and he's sort of testifying about what happened. And a big part of this, is it's very foundational. This is all, we all kind of know this stuff already. This is all right. So what, right? We all know what happened. There was an alleged counterfeit $20 bill. He gets pulled out of the vehicle. We're sort of framing out the situation. There's an arrest that takes place. Then, there's a couple important questions. What was the cause of the death? And then was there, last minute ingestion, last minute concealment? Was there a response that Chauvin should have done that he didn't do that was in violation of police protocol? And none of these witnesses are really giving us any indication about anything about that, right? They're not helping us on answer those questions. They're framing out, they're laying the foundation for the good information, the stuff that is going to be dispositive. Dispositive meaning it's going to help us decide one way or the other. Okay, the 911 call, she going to help us answer those questions? Not really. Is the Arizona gal going to help us? No, not really. Is this guy, martial arts background, law enforcement background, going to help us answer whether or not the knee killed George or the fentanyl killed George? No, not really. But it is useful for framing out the sort of the first level of analysis, for setting the scene, and that's what this guy did. So let's take a look at some of the questions over from watchingthewatchers.locals.com. We've got some good questions in the house. First one comes over from J-Bone. J-Bone86 says, so apparently the autists on the interwebs have identified the third witness today, probably the guy we just talked about, participating in riots, and busting out windows of police vehicles. Can the defense confront the witness with this at all? Yeah, so I think that they certainly could. I think that you'd probably get an objection from the prosecution saying, oh, that's not relevant, right? Who cares if he was busting windows out of police vehicles? That's not relevant to what he saw here today on that particular incident. And the defense would just say, yeah, but it does go to his motive. It does go to his credibility. In other words, somebody who is very, very prolific in participating in riots and participating in unrest, somebody who's very adversarial against the police, would not be a particularly credible witness in this case. And so, yes, you can challenge and impugn the credibility of witnesses all day. Whether the defense wants to do that or not is a different story, right? Think about that. Whether that is the battle that they want to have. Does it matter? Does what this guy said in court today matter at all? I don't know, right? And so if the defense wants to come out and say, hey, sir, so isn't it true that you were launching Molotov cocktails at the 3rd Precinct over there in Minneapolis, the same one that Kamala Harris was using to get you out of custody? Were you involved in any of that? Like, yes, they could bring that up, but what is that? What does that do? Does that move the needle forward for the defense? I don't know. So yes, they could. You can definitely impugn somebody's credibility if they're a witness, but whether they do or not is a decision that the defense would have to make. News Now Wyoming says Court TV said the defense inferred that bystanders yelling is partially to blame to why Chauvin kept his knee on Floyd. Do you think that could end up hurting the defense case? So that the defense inferred the bystanders yelling is partially to blame why Chauvin kept his knee on Floyd, do you think that could end up hurting the defense case? So if there, it depends. It depends really what the facts here are. If there is evidence that Chauvin was violating the policy, the Minneapolis Police Department policy, by keeping his knee on the neck, then that is ultimately what I think harms the defense. If there is the defense saying, I kept my knee on his neck because there's also elsewhere in the Minneapolis Police Department policy, there's also rules and provisions that say if you are being assaulted or if you're being, potentially assaulted by outside influences, by crowds or other people who might interfere with your investigation, I'm going to guess that there is some guidance on that. What are you supposed to do about that? Are you supposed to just kind of drop everything you're doing and go attend to those other people? Or are you supposed to secure the scene and make sure that they do not interfere with your investigation? In other words, preserve your investigation at all costs. So if that is the case, then even though that there's a scenario in which Chauvin was in violation of the policies technically as to that one small specific policy about the knee on the neck, they may be referring to another part of the manual that says, yeah, but I had to keep the knee on the neck because we were being assaulted by outside people. There were other factors that led me to sort of prioritize my obligations. I've got an obligation to preserve life. I got that. I've got an obligation to protect and preserve the crime scene. I've got that. I've got an obligation to protect my fellow officers. Got that. Got an obligation to sort of keep the public at bay. Got it. And so he's got these different priorities. And the question is going to be, did he organize them appropriately? Government's going to say, no, he didn't. He should have gotten off. Defense is going to say, yeah, he did. He had no choice. This is exactly what he had to do. So we'll see where it comes out. We have NY Renal MD says, I saw the testimony today from the MMA expert. Why didn't the defense object to his testimony being constrained to just what he saw, not as a medical expert? So I think that they did. They filed that motion in limine about that one specifically, about that witness. And I didn't listen maybe as closely as I could have, but I didn't hear anything where he was saying that as a medical expert. In other words, I don't think he was testifying as a medical expert. I think he was testifying as somebody who's had some formal training in MMA and those types of things. But there was, if I'm not mistaken, there was actually a motion in limine about that. But the real question on that witness is how consequential is that person going to be? We have no doubt, says the prosecution showed the video of the event at a potentially slower speed where the rocking of the police SUV is barely noticeable. The defense played the same video at normal speed and pointed out the significant rocking movement of the police SUV. However, he didn't really explain the importance. Is that something he is saving up until later, or is that a poor job of pointing out a misrepresentation by the prosecutor? So it's a very good question. So, sometimes it can really go either way on this thing. I think that a lot of these types of things they have the biggest effect during the closing at the end of the case, because then you can go to the jury and you can say, listen, you've got all of these exhibits in front of you. You've got their version of the video. You've got my version of the video. My version of the video, as you can see, is shot in real time. You can notice that just as a regular person, because you can see some of the natural movements. You can see the street lights changing. You can see people walking around. You can see the rocking back and forth of the SUV. This is what really what happened in reality. The government, they're bending the facts. They're manipulating things. Go look it up yourself. Go look at Mr. Jurors. Go back in the deliberation room, play their video, play my video. Why is ours right, theirs wrong? That's where you make your arguments. And that stuff is pretty powerful. And if the jury feels like the government is intentionally misleading them by moving things around, they lose credibility throughout the entirety of the case. And so maybe you just let them keep doing that. If I'm a defense attorney, I think that's what I do. I just say, all right, well, they're just manipulating things. Go for it. Keep going. Manipulate everything. And then you just skewer that in the closing. Good question. We have Osak71 says, hey, Rob, welcome back. Big fan of the show. It's good to be back, Osak. I missed you guys. I don't like taking time off the show, but sometimes I just got to prioritize, unfortunately. But I'm glad we're back. So question, why would someone change their plea to guilty right as a trial starts with no deal from the prosecution? So it's a good question. It happens a lot. Sometimes what would happen is, let's say somebody is concerned that the sentence that they would get after a trial would be worse than the plea deal. So you're saying there's no deal from the prosecution. That may be true. They may be going in. I've had judges specifically say, that if this goes to trial, they're not sure what the penalty will be. But they know that if it doesn't go to trial, they're pretty sure this is what the penalty will be. In other words, if you take a guilty plea, they're going to give you the minimums. If you go to trial and lose, you might not get the minimums. You might get something more significant than the minimums. This is called a trial tax. You're sort of penalized by exercising your constitutional right to go to a trial, which is absurd. It's nothing that is formally written in policies anywhere, but it is a reality. Judges don't like to waste their time, as they see it, on a trial, even though it's your client's constitutional duty, constitutional right to have that trial. Judges will say, well, if he just goes and pleads to the court and just accepts that he's guilty, well, we're going to accept, you're going to say, hey, that he's accepting responsibility. We're going to reduce the sentence. If you go to trial and lose, the judge might say, hey, you made me sit here for 3 days through a trial that I didn't need to sit here for. You were found guilty anyways. Therefore, I'm going to give you a little bit extra penalty just to make sure that it stings. So that's one reason. OSOC also says, Rob, would it have been better for the defense to reserve its opening statement until the end of the government's case? You know, it's a good question. You can sort of defer your opening statement. You let the government present their case, then you come out and present your case. I don't think so. I typically don't like that as a strategy. I think that it's important that you introduce yourselves to the jurors. You sort of at least frame out some of the potential pitfalls in the government's case, because you want to flag them. You want to sort of give them things to look for, or give them an alternative that they can hang their hat on. You want to give them something that, like, every time they hear that word, they go, ding, oh, okay. Ding, oh, there it is again. Oh, I'm supposed to be paying attention to that. And so you go through, and I'm not real sure that he did that in his opening statement, but at least they know of him, and they know what he's going to be talking about common sense. So if his theme is common sense, use your common sense. Every time he gets up there and asks a question of a witness, and he maybe references common sense, maybe the jurors go, oh, there it is. There's that word I'm supposed to be paying attention to. Oh, I guess I'll wake up now and listen to him. So it's establishing the theme. It's giving the jurors a pattern that they can follow as the case unfolds. And I think he's playing it right thus far. So good questions. Once again, those came over from locals.com. That's our little community that we have building up over there. It's not even a little community anymore. It's growing by leaps and bounds, thanks to all of you. So it's watchingthewatchers.locals.com. Those questions came over from there. If you want to join up, you can head on over to that website and do so. All right, so good stuff on that segment. We're going to change gears, and we got a lot more to get to, so we're going to pick up the pace a little bit. I just wanted to spend some time on Chauvin because, man, we're going to be in this one for the next couple weeks. It's going to be fun.